Welcome to Season 6, Episode 8 of Fire Away, Rudner Law's online show focused on the employment law issues that matter to you. My name is Stuart Rudner. I'm an employment lawyer and mediator, founder of Rudner Law, and your host of this episode of Fire Away. We stream live online every month, and if you missed an episode or want to watch one again, they're always available on our YouTube channel, on our Facebook page, and on our website. Today, I am very excited to be joined by Sean Bawden, who's an employment lawyer and litigator at Kelly Santini LLP. Sean is not only a colleague and a friend, but I have to say I'm a bit of a fan. Um, Sean is one of a small group of people within the employment law world that I would consider as a go-to resource, who just seems to know anytime there's a new case, new development, and he provides tremendous analysis, including a paper that Sean was kind enough to send to me last week on an interesting issue that I'm still trying to get my head around. And best of all, Sean has a blog on labor and employment issues with perhaps the best name I've ever heard. Rob, are you trying to get my attention? Oh, sorry, I saw a finger up there. All right. As I was saying, Sean's got a blog on labor and employment law with perhaps the best name of any blog. Sean, your blog is Labor Pains, which I wish I had thought of and taken. Anyways, Sean, thank you so much for joining me today.
Thanks, Rudner, and thanks for saying those things. I will say that when I was getting into the world, I was trying to emulate you, which I don't think I've ever told you that. But I do recall that you were sort of leading resource at the time, 15 or so years ago when I was doing this. So that dates both of us. Anyways, so I appreciate you having me on. Appreciate to have the audience. Anytime that I can stroke my own ego by speaking to people, I'm glad to avail. So I will use you as a foil this afternoon to talk about mediations and how to get them done from two sides of the table.
Awesome. Well, I appreciate you doing it. Happy to allow you to stroke your ego, and then you've sort of stolen my thunder. By introducing the topic, we're going to talk about mediations today, which is where I'm spending a lot of my practice these days, where I get to act as the neutral third party, which is something I really love. But this kind of came out of a post that I made on LinkedIn a few weeks ago, really out of frustration with counsel who kind of write their mediation briefs like mystery novels. And I read the whole thing trying to figure out what the real issues are, what they really think their strengths of their case are, if there's any evidence, how the case is going to be resolved, if there have been any settlement discussions to date. And I kind of posted about that, and then you chimed in and basically explained what you do in your briefs, and other people chimed in as well. But I realized that you and I seem to be on the same page as to how to be strategic in the mediation, both in the briefs and at the hearing. I thought it could be a great discussion and hopefully helpful to viewers. Most of our viewers are not lawyers. Most of them tend to be in HR or in business, or we also have individuals. But hopefully they will also hear what you have to say about what a brief should look like. And when they're working with a lawyer, we'll make sure that their lawyer does these things as strategically as possible. So when we start with the brief, which is where our discussion started a few weeks ago, and I complained about the fact that many of them are like mystery novels. I'd love to hear a bit from you about what you do. And the one thing I neglected to say when I introduced you, Sean, so bear with me for another 30 seconds. Sean was in private practice for many years and was in-house for a few years and is now back in private practice. So you can speak to this both as external counsel, but also from the client perspective. So with that, I'd love to hear from you more on how you're doing your briefs these days.
Thanks. Yeah, and the benefit of being in-house counsel is that you get to see other people's styles of how they do things. So I unabashedly stole my current style from someone else. I probably put my own spin on it. But whatever the current incarnation of my brief is not mine. I stole it from somebody else. I just do it better. So, what I try and do is write to the mediator, right? And try and leverage the fact that I am bringing in an independent third party who knows nothing about this case to assist me and counsel opposite and our clients get a deal done. Because, Stuart, if you're showing up, we haven't done that yet. And in employment law cases, frankly, we get that done often before we have to pay an independent third party to come in. So
Yeah.
clearly, I mean, people in this world know sort of what's at stake. They know the various issues. So if we haven't hammered out a deal between us over the phone by email, then there's clearly an issue that we can't agree on. And frankly, I see no point in not telling you, the mediator, what that issue is. So, I start my brief with the first page. I call it what the mediator needs to know. It is one page. If I can't get it down to one page, I don't know my case well enough. So, and the first is a couple of bullet points of things I would tell my non-lawyer spouse or, junior in my office, what this case is about and what this mediation is. What do we got? And then what the issue is. And I put in bold, here's the issue or issues, the real issues. Not, this is a wrongful dismissal case, the issue is notice. No, it's not. No, no. The issue is a termination clause. The issue's, stock up. Like, what is it? What's the issue? And I don't put positions in there and often. And then if it's a notice case, I have a table of Bartles on one page. And then I will put something about how the mediator is going to be helpful from my perspective. And
right. And I love that part. And sorry to cut you off. And just in case anybody's not sure, when Sean's friend table of Bartles, those are the Bardol factors, which is the case that predates both of our careers, Bardol versus Globe and Mail, which set out the key factors that we always look at when assessing notice. So the length of service, age, nature and character of employment, and availability of similar work. And as I often say, you can bury that in your brief, and you can spend 9 paragraphs talking about all those things and make me read through it and highlight the little parts that I can't get, or do what Sean does and just have a table with all the key data right there. But then I love what you were sort of just starting to talk about. I have to admit, as I've gotten more comfortable and confident in mediating, and especially if it's a lawyer that I know, I'll often start off the day by saying, why are we here? Why haven't you been able to settle this on your own? Because as you said, Sean, most cases can't be settled. So I love the fact that you're kind of trying to address that right up front at the beginning of your brief of what the real issue is and how do we get this resolved, or why haven't we been able to so far. I'd love to hear a bit more about, like, what would you, maybe an example of what you would put into to do that.
Yeah. So the last sort of true employment one I did. It was a dispute over whether or not the termination clause was dispositive. We, basically had agreed on what the notice period would be if anything was owed at all. But the real tension was my client, the employer, said that its employment agreement was solid. Employees counsel says, no, your employment agreement's, garbage. So wrote common law. That was about it, right? We didn't need a lot of back and forth on what the damages would be. It was a liability case. So I said as much. I said, look, here's the sole issue. It was the second mediation we had in the case. And so I said, here's how the mediator's helpful. You got more experience than the two of us put together. Give us your honest opinion. If you want to do that in caucus, that's fine. But we're hiring you, because you arbitrate. So I'm not asking you to arbitrate this, but I sure am asking you to make a call. And then I just set it all out. I gave in my brief, I appended the employment agreement. I sort of addressed their issues such as they were with documentary evidence that we had. And the brief was all of absent attachments, 8 pages. Like, I'm trying to make them short now.
Right.
And then, append evidence where I have it. All those things, Stuart, that you asked for, I try and anticipate.
Which is amazing. And as I somewhat or sometimes jokingly say to people, we use the word brief for a reason, even though we don't always follow it. But it is great when the brief can actually be short and succinct. But then you just hit on another one of my pet peeves, which is evidence. It is amazing how often, not a case like you're describing where it's a contractual question, but let's say a cause case. It's amazing how often it happens where the employer says, we have evidence to prove that the plaintiff did A, B, C, and D. And when I say, where's the evidence? They'll say, oh, well, if we don't settle the mediation, we'll get it. Which is just a horrible approach because I want to be able to assess the evidence because that's how we're going to figure out where this case should settle. So A, you should have it, and B, just like you're talking about with your one-page summary, spoon feed it to your mediator. Like there's nothing I like better. I got a brief a few weeks ago, which and again, one of the points I often make is we're in 2023 now. Your brief doesn't have to look like it did in 1992. You can embed documents, you can embed videos, you can embed audio recordings right in your brief, or at the very least have a link to it. So I saw one a few weeks ago where the individual was accused of punching his colleague. This is in a factory. And right there in the brief, right below the paragraph that said, on this day he punched his colleague, there was a YouTube video. And I clicked on it and I got to watch the video. And then they added their own color. And of course, there was some argument. But I could see what a judge was going to see if this thing went to trial. And that to me is the best way to do things.
Agreed. And as I said to you when we were talking about this, you're a resource. You are a tool. Sorry, that's going to sound odd. Resource isn't
the way you intended it.
not for attribution. Sean Bawden said Stuart Rudner is a tool. But you are a resource in this process. You're an independent third party coming in, same as a judge will later, right? Who knows nothing about this, gets it fresh, and we'll see different things. We'll see things different than our clients have articulated, or we'll hear it differently than we did. And the word I sort of describe in going into this is that counsel needs to be vulnerable. Counsel needs to lay it out as best they have it and say, frankly, mediator, what am I missing here? Right? What am I not seeing? What is the other side seeing that's giving them the confidence to be at this point? Here's what I have. Here's all that I have. What am I missing? What more do I need to get? Because I'm not at trial. I still got time to go and get it. But listening to what the mediator says of, I want to see X, Y, and Z, I try and anticipate, but heck, if I'm that good, I'm not. You never know what's going to inspire or capture the imagination of a judge, of a mediator. So I want to know that. I want a trial run of my day with someone I know and trust, knows the issues, perhaps better than a generalist judge, who can draw that out of me. And that's what I'm hoping to do. But I can't, Stuart, to your point, you can't have that conversation if you haven't given the resource. If you spend your 3-6 hours giving things that could have been in your brief, you're never going to get to the real issues, right? You're going to spend all the time in the warm-up. You're never going to, throw the ball.
Well, that's as Justice Laskin used to say, forget the wind-up and make the pitch.
Yeah, I was trying to make
But you hit on another one. I think I have a lot of pet peeves. Apparently, you hit another one, which is especially employment law counsel seem to have this habit of booking half-day mediations, which is 3 hours, and then of course they serve a mystery novel for a brief. So I spend 2 of those hours trying to figure out what happened and what the evidence is. And now all of a sudden we're sort of in the last hour. Now we're finally talking about how we can settle this case. Yep. So A, I think it's often more prudent to book a full day. B, if you can put all the evidence up front, then you can avoid wasting the first couple of hours and we can really get into the meat of the case. But I was going to shift gears slightly because you kind of gave me a good segue to another thing I want to talk about. You talked about 2 things. A, using your mediator as a resource or a tool, as you put it, because your mediator is going to be the first neutral third party observing your case. So, and assuming that you retain a subject matter expert, then you should take the time to listen to what they have to say and how they see the case and what strikes them as strong and what strikes them as weak. And you also said, that you should be vulnerable. I was curious on that front because I find a lot of our colleagues struggle with that. because they don't want to seem weak in front of their clients, or they don't want their clients to feel as though the case is weak. They sort of refuse to listen to anything negative. And I was curious as to how you prepare your clients for the mediation in the sense of, you know, going in with a bargaining position or a bottom line, and how much they should, I guess, pay attention to what the mediator has to say when they're assessing the case.
Yeah, so I mix a few things. First, I usually tell them about the mediator and how he or she was selected. I mean, usually we are agreeing on them. Counsel will put someone forward, and then there's agreement. And so where that's being done, uh, we're selecting you for a reason. Usually, rarely anymore is it price. I if I I like to think I know a thing or two about this area. And so if I haven't got it done, and often opposing counsel knows a thing or two as well. So, if the two of us can't get it done, I want a subject matter expert. I want someone who knows their way around, knows what they're doing. Um, and I'll say to the client, like, look, I don't know where the issue is. I'm going to make our best pitch here, but I didn't retain Stuart, because I don't care what he thinks. And you don't have to listen to him. And if he's having a bad day, we won't listen to him. You can't force anything on us, but he's here for a reason. He's an independent set of eyes. And, we're not going to get that luxury when we walk into a courtroom. We may not get Stuart Rudner. You get commercial transaction lawyers, you get family lawyers, you don't know what you're going to get. So
Yeah.
this is probably our best swing at it. So let's hear what he has to say. And if it's really bad, I'm going to trust most mediators with whom I work to pull me aside, into the hallway, real or virtual, and tell me where the warts are. But that requires the trust in who you've selected as your mediator to know that there are issues. And then I can take that information back to my client, distilled or sterilized as I see necessary. But again, counsel needs to be prepared for that conversation to happen. And, to say to the mediator, like, look, if you got something to tell me, tell me. If you don't want to embarrass me, now I got to trust the mediator not to do that. And I do trust that you're not going to do that because I won't book you twice. So, that's just
Yeah.
smart business on your part. But if you're
Yeah.
not prepared to have that conversation, no one's infallible.
Yeah. No, I think, and from a mediator perspective, I can tell you, sometimes if I've got counsel taking a position that I think is just wrong, and I don't know if they actually believe it or if they're just saying it in front of their client, I always encourage counsel. You can always call me before the mediation and just say, here's the issue. And if you tell me that your client just won't listen to your advice, and you need me to help you, then that makes my life easier because I know I'm not undermining you. I'm just reaffirming what you've been telling the client. So by all means, as counsel, let your mediator know if there's an issue with your client that you need help with. But also to the bigger point, you've retained, hopefully you've retained your mediator for a reason. They've got some expertise. Listen to what they have to say. And I'm curious as to what you do. It might be different with different clients. Because the other challenge we sometimes encounter is that I'll frame this from the employer perspective, because usually the defendant, of course, the one who will be paying the money. They'll come in and say, "Well, we met last week, and our absolute bottom line is we're not paying any more than $50,000." And the problem with that is you've decided on that bottom line before you heard from your mediator, before you got their insight into the case. So maybe what you thought was a $50,000 case is really a $150,000 case. So when I work, when I'm preparing a client, I would say, like, we can have an idea, of course, of where we're realistically hoping to end up, but let's not have a bottom line because we should only assess that once we hear from the mediator. And some clients won't listen to that and they come in with their bottom line anyways. But curious as to your experience and whether you're more successful than I am in getting clients to come in without a firm bottom line until they hear from the mediator.
I think my greater challenge half the time is that clients aren't always completely candid with their lawyers either,
Mm.
as to what their authority is, what their bottom line is. It gets harder the larger the client. It's a small operation and you're dealing with the owner founder and it's not insured. You got a pretty good, and got rapport, you got something. You get into a multinational reporting to New York, who reports to Geneva, who, whatever, you have no idea anymore half the time. And you think you got a good client contact, but there are decision makers who aren't in the room sometimes, and that's where it really gets challenging, is getting the right person with the right authority in the room. Right. When I was in house, I was the subject matter expert on labor and employment matters. Great. I would go to the mediation. I'd sit with external counsel. I didn't control the money.
Right.
So I made recommendations, but my recommendations went to my boss. He sent it over to finance. Finance sent it to their, like, you know, so I've told my external counsel what I think it's worth and what I think we should be doing, and I'll be there in the mediation. But sometimes having the right decision maker, it's the nature of global business now. So that can be hard.
Yeah, it's one thing that Zoom has improved a little bit. Is, it used to be, if in your example, if the ultimate decision maker was in Geneva, they
Yeah.
probably weren't flying to Toronto for a low level wrongful dismissal claim, but
No.
you might be able to persuade them to participate by Zoom. So I do find I'm getting more decision makers participating more fully, but we still have that all the time where I've got to call so and so,
Yeah.
and then of course so and so has not been privy to all the discussions, so they can't figure out why we could possibly recommend offering what we're suggesting. So,
Right. And they
uh,
haven't sat in over the last 3, 4, 6 hours to see how the sausage was made.
well, that's exactly it. There is a real process to mediation. I mean, I'll share a quick example because I think you'll find it interesting. Hopefully, viewers will as well. But mediation is a process, and people have to go through it, and people want to be heard, but they also have to hear from me or whoever is the mediator, right? I had a situation about 3 years ago where there were two plaintiffs suing the same company. Both plaintiffs were represented by the same lawyer. The company, of course, had the same lawyer. So we thought we'd be efficient. We scheduled one in the morning, one in the afternoon on the same day. And of course, the morning went long. So we're now at about 3 in the afternoon, still negotiating. We'd now been spending 5 hours back and forth, working towards a deal. And we finally got to a deal. And the facts were almost identical, to the point where the settlement range was really going to be the same, within a few $1,000s. So it's now about 3:30 in the afternoon. We're starting the second mediation. I thought I would be really efficient and just cut to the chase
Yeah.
and said, we've been through this and we've talked about it, and realistically, your case should sell for X dollars.
Yeah.
And that woman almost bit my head off because she could not imagine why she would possibly accept such a low dollar amount. And I then had to apologize and backtrack and realize that she had not had her quote unquote day in court.
Yep.
She hadn't been heard, and she hadn't heard all the discussions. And we had to start at the beginning and go through the process again, even though we were all kind of repeating ourselves.
Yep.
But as soon as we did that, and I think we were a little bit more efficient, we got to the same place. But you can't just skip the whole process. And that's a really good lesson for counsel to learn, I think.
No, it is a process. It has to be done. Those of us who do sort of the same thing all day, every day, it can seem sometimes there can be a desire to sort of skip to the end and where we all sort of know it's going to land. But you got to remember it's the client's first time in a lot of
Yeah.
cases, or at least the plaintiffs. Maybe not. It depends on, I say client, but it's often the plaintiff's first time, perhaps only time. And mediation, pretty rough justice. It does not look like television. It doesn't look like they thought. Zoom hasn't helped that in terms of formality and grandeur of all of this. So it takes a little bit of time to get comfortable that this is real, that this is actually how business gets done. It's hard to believe that sometimes. It's still weird when you really take a step back. And you got to have trust in everyone. And, when I was the client, even though I had been there as counsel, there are some weird things we do. And, one of my takeaways, and I'll use this one for mediation, but I talk about you pulling me out into the hall, real or virtual, and mediators do this and counsel do this all the time, where you ask us to step out or lose our client. Um, Gotta let your clients know you're going to do that. Gotta let your
Yeah.
clients know that at some point you're going to abandon them, because it's really odd, and then they got to trust you implicitly that you're not selling them down the river while that's happening. And even if you've been external counsel and done this, 100 times, I got to tell you, the first time my external counsel ditched me to go to the hall, I'm like, well, I don't like this at all. I know what this is and I know why you're doing it, but
That's a great example. Yeah, it's funny. I learned that very early on, and now in my introductory spiel, I always speak to the clients and say there may come a time where I ask to speak to your lawyer. You haven't done anything wrong. Don't worry about it. And I try to reassure them. But that's a great point that even you, who clearly know what this is all about, even you can sort of feel left out and wondering what's going on in the other room.
yeah, because you're not hearing it. I mean, I think that's you're not hearing the issues, you're not hearing the mediator's sort of candid take on it. And it then becomes a question of what's taking them so long? Why
Yeah.
have it gone so long? So yeah, just being mindful of that and being prepared for that if you're the client, is probably the best way. And so if your counsel advised them that's going to happen, I can now sort of do the whole I've been there thing. I find
Right.
that super helpful, honestly. But
Yeah.
if you're not prepared for that, that's one thing where I think counsel can do a better job preparing their clients for mediation, is knowing that it is a process and very, very little is new. So here's what it's going to look like. We're going to pack up our bag at one point, make a big show, go in the elevator. We don't do that as much anymore, but
Yeah, we don't get to do that in the Zoom world,
oh,
unfortunately.
yeah. I did log off a mediation once,
Oh,
and then got a call from the mediator to never do that again. So
I haven't had anybody do that to me yet, but I've had people threaten to, but no one has done it yet. But look, and that's all part of preparing your client, right? Sometimes you're threatening, sometimes you're bluffing, but they just need to know what's going on.
yeah,
Um,
we weren't threatened. We got the deal done eventually, but I think that mediation took 7 days.
oh
Uh,
wow, yeah, that's a pretty lengthy mediation, but you got the deal done.
yeah, it was it was a collective bargaining deal, so there were a lot of issues. It
Hmm.
wasn't sort of a discrete issue, but yeah. Uh, Anyways, don't leave. I guess is what I would say. It was easier. And I said, look, in the old times, you walk to the elevator, maybe you go downstairs, and you come back. He said, yeah, you can't do that
Right.
on Zoom. And I
No,
said,
and
yeah.
especially in the wintertime when you had to pack up and put on your coat and your
Oh, it's
scarf
great
and your
theater.
gloves. There was
Yeah.
lots of time for the mediator to come and quote unquote drag you back.
Right.
Zoom was a
Yeah. I
little
mean,
different.
but and look, it was early in like 2020 or 2021. It was easy to hit the button, right?
Yeah.
And then too easy. Whereas in the old days with your stuff in your bag, yeah, it was a show primarily. And then the media would say, no, 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 you're not leaving. No one stopped me. I was in my house by myself. The next thing I
Yeah.
knew,
No.
I was
Different
not in the
strategy.
room anymore and went, oh, I shouldn't be here alone. So, anyways.
Well, sounds like you got it back on track. So,
Yeah, yeah. So, anyways, I know
anyways, as
the
as
hour.
as we predicted, the time has flown by. It's already
Yeah.
almost 1 o'clock. So I'll oh, and we have a question on YouTube. Does your client's native language play in your selection of a mediator? To what extent? Uh, that's a great question. Yeah, Sean, do you want to jump on that first?
Yes, it does.
Especially you're in Ottawa, so you would appreciate more than most.
Yeah, and that may be it. Yeah, if my client would prefer to express him or herself in their native language, I think that's helpful. In Ottawa, it's usually French, so if there's not a lot of bilingual mediators, I think that makes sense. Because to your point, if they feel the need to be heard, there's no sense them having to put it through their own head to translate. So having someone who speaks, and frankly, I would prefer that English be their second language, and then have a harder time with me than with my client in
Right.
that case. So
Yeah,
Yeah.
that's a really great point. Yeah, it's interesting. I mean, I grew up in Montreal, so I like to say I can understand French now. My spoken French is not great anymore. But I did have a mediation a few years ago now where the plaintiff was native French speaking and spoke English very well. But every now and then he would just stumble, and the relief on his face was priceless. When at one point I said, "Go ahead and say it in French. I'll understand it," and he was just so happy. And all of a sudden, so then, and I said, I'm probably not going to speak to you in French because I will sound like a 3-year-old, but I'll understand what you say. And you could just see he felt like he actually was being heard. And it wasn't just a bunch of Anglophones sort of interpreting what he was saying. So, yeah, I think that's a great question. So, Jean-Michel, thanks for sending that in. But I think it's a really important point that if you want to have a subject matter expert, but depending on the native language, there should be someone out there who is both subject matter expert and can speak the language of the parties. So
Yeah.
it's a great factor.
Yep.
Guys,
Yeah.
we're now after 1 o'clock, so I
Yeah. Okay.
better wrap things up. But I would love to have you back again because there's a million things we can talk about. But listen, Sean, thank you again for doing this. Great conversation. I really appreciate you taking the time.
Well, thanks for having me on, and you know where I am. So happy to do so.
I know where you are, and just so everybody else knows where you are, you're at Kelly Santini LLP, so and physically in Ottawa. So great, Sean is a great resource online on Twitter and various social media as well. And again, check out Labor Pains, his blog. So
Appreciate it.
that's a wrap for season 6, episode 8 of Fire Away. So I want to thank everyone for tuning in. I want to thank Sean Bawden again for joining me today. Just a quick reminder that past episodes can be found on YouTube, and if you like our channel, and follow us, we very much appreciate it. You can also find them on Facebook. You can like our page. You can subscribe to our channel, and you'll get notifications when episodes are live. Our next episode is going to be October 17th, when I will be joined by John Rodriguez, founder of John Rodriguez, founder of Empathic Security Cultures LLC. Lastly, but not least, at Rudner Law, we always want people to treat their employment relationships as legal relationships and to make informed decisions as opposed to assumptions. So I invite you to keep up to date on employment law issues by following us on Twitter and Instagram and LinkedIn, as well as checking us out on TikTok, liking our Facebook page, subscribing to our YouTube channel, and subscribing to our newsletter. But as we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So feel free to reach out to us. Thank you to Rob, to Rebecca, and to Mark for helping to put the show together. And thanks for tuning in. We'll see you next time.